Hey guys, it's Joel Williams and Chase Elleby coming to you today from Williams Elleby. We're going to start with our week 3 of our video series of 52 weeks of personal injury, and today's topic is going to be how to give a deposition. So Chase, what would be your first tip or instruction for someone getting ready for a deposition?
Right. Well, I think first it's important. Let's talk about what a deposition is. And simply, it's just the other side getting sworn testimony from you as a witness about facts or whatever the case may be. So I think as a practical matter, the first thing to sort of be on the lookout for or to remember is just to dress appropriately, right? You want to make a good first impression, so don't show up in a ratty t-shirt and shorts and things like that. Dress like you're going to go to court.
Gotcha. All right. Yeah, that's a good point. And the second thing I would say is probably the most obvious of everything, and it's just to tell the truth, right?
Right.
The truth of the matter is, in depositions and even in trial testimony, is that when an attorney asks a question, he or she usually already knows the answer to it, right? So if you think you're going to be able to hide something or fluff the truth or anything like that, it's actually probably nothing could be further from the truth.
Right.
You know, the attorney's going to catch you, and you would be made to look like a fool if you are dishonest during a deposition. So just don't do it.
Right. Exactly. And it's easy. Telling the truth is the easiest thing to do, and it's the easiest rule to remember when you're giving a deposition. So the third thing I think that is important is to be polite, right? A lot of times people think depositions are going to be this real contentious, heated back and forth, and very rarely that's the case. Most of the time it's just simply a question and answer session. And some of the questions are going to be difficult. Some of the questions are going to be, obvious what the answer is. And it's probably not going to be the answer you like to give. But it's always important to be polite and show respect to the other side and not get heated.
Yeah, I've always thought that if the other attorney is starting to get angry and frustrated with you, if you're being polite and they're getting angry and frustrated with you, you're winning.
Right.
If you start to lose your temper or get angry or lash out, as if you're the victim and the plaintiff in the case, then it's more likely than not you're hurting your case at that point. So real emotion is fine because we're human beings and we're going to have emotion. But when it comes to anger, we need to be polite and professional anytime we're giving a deposition, I think.
Right. And that leads to another tip, talking about emotions is, it's important to show emotions, but don't be fake about it, right? Don't try to oversell it or whatever it might be. Because as lawyers, and even as jurors, right, we're trained to kind of sniff out what we think is disingenuous. So it's always important to just kind of keep it in check if you can, but also don't try to oversell it.
Yeah, exactly. And I guess kind of piggybacking off of overselling it, when you're asked questions during a deposition, it's usually best to give short and direct answers. A deposition, whether you're the plaintiff or the defendant in the case, is not the time to try to win your case. A deposition is a time where your sole job as the person that's being asked the questions is just to answer the questions. It is your lawyer's job when you get to trial to ask the correct questions to get the evidence in that's needed to win your case. But a deposition is not the time to try to oversell it or to try to win the case.
Right, that's right, exactly. And I always say, listen to the question and answer the question that's asked. Kind of in that same vein, depositions are not necessarily memory contests. You're going to have to know certain facts about your case and things like that. But you don't have to guess, right? If you don't know the answer, I don't know, I don't recall, or fine. And a lot of times the other attorney who's asking the question can see that my client or whoever the witness is might be kind of struggling. And let's say, don't guess. We don't want you to guess. You either know or you don't know. Guessing can only put you between a rock and a hard place, and maybe slip up and say something that you don't really mean, but you're just trying to be helpful to the person asking the questions to get information that you think they may want. So it's important not to guess.
Yeah, and I think one of the tactics that I like to use when I take depositions, I'm always going to be friendly and nice with the other side, especially the deponent, because usually when they're comfortable with you, they tend to give you more information, right?
Right.
And if it's a witness that's against my case, or if it's the other party in the case, if I'm cordial with them, if I like them, if we have a flow of conversation going on, I may be able to get them to guess.
Right.
And they testify to something that's helpful to my client.
Right, and not necessarily just even guessing, but you might get them to sort of open up because they trust you and you're kind of in the flow of the conversation, and they're just more willing to, I guess, help out and give information. So
that's right. And then once you get people into that mindset as an attorney, usually, at least for me, that's when I switch to what we call leading questions. Because there's two types of questions that you may be asked in a deposition or even at a trial. The first is an open-ended question. And an open-ended question is sort of a softball to you to give you the opportunity to tell a story. So a good example of an open-ended question may be, Chase, tell us what you were doing that morning before you were in this car wreck. And then Chase could then proceed to say, well, I woke up at 6 o'clock, I took a shower, I brushed my teeth, I ate breakfast, I got in my car, started driving, blah, blah, blah. But a leading question is much different. And a leading question gives the attorney the opportunity to phrase the answer and have you agree with it. So, for example, a leading question may be, in a car wreck case, Chase, isn't it true that 37 seconds prior to the impact occurring in this case, that you pressed send to call your wife on your cell phone? And that's either true or it's not. And Chase either has the opportunity to say, well, yes, that's true, or no, that's not true. Or if the entire leading question, the entire portion of the question is not true, then that would be your time to disagree with it, because it may be true that 37 seconds before the impact that Chase pressed send on his cell phone to call his law partner, Joel, but he was not calling his wife, because we're certainly not married. Then you would say, well, part of that's true, part of it's not. But the whole point of this advice is to sort of let your antennas go up anytime you hear a leading question, because when you get that leading question, you should understand that the attorney is phrasing something in the way that he or she wants it to be phrased and preserved in the transcript for later on.
Yeah, that's exactly right. And speaking of antennas going up, not a lot of times, but sometimes in depositions, especially in discovery depositions, there may be objections from the lawyer who's defending your deposition. Rarely am I objecting in depositions, because discovery depositions, whoever's asking the question has very wide latitude to ask a question. And just because a question is being asked in the deposition doesn't necessarily mean that's going to be admissible at trial as evidence. So a lot of times my clients are like, why are they asking this? Why were they asking that? It's not a big deal. They have a right to know, but that doesn't necessarily mean that the jury's going to know about it, or the trial court's going to hear about it. But anytime you hear an objection, that's always, your antenna should go up and say, okay, what was wrong with the question? Because usually an objection is to the form of the question or the responsiveness of the answer. In the form of the question, that's things like compound questions, where I'll ask 2 or 3 questions within one question and sort of kind of not necessarily trick you, but you kind of get confused as to which question you're answering in which sequence. So anytime a lawyer objects, it gives you an opportunity to sort of reset, listen to the question again, and then pay close attention to it.
Yeah, I think that it's usually a good idea, if your lawyer objects during the deposition, if you could just ask the other lawyer to rephrase the question, just so you can make sure you understood and listen to the question again, to see if you might be able to pick up on what your lawyer was objecting to.
Right. Because
your lawyer cannot have a speaking objection. They're not supposed to have a speaking objection. They can't kick you under the table and say, oh, hey, look out for this and that question. That's just not the way it works. So it's always a good idea to ask them to rephrase the question after your lawyer objects. Another type question to be wary of are time and distance questions, because if we could bring 100 people into this room right here and then ask them, how far is the road that's in front of our office from where you're sitting right now? And we'd probably get if we got 50 people, we'll probably get 50 different answers, right? Because we're just notoriously bad at estimating time and distance. If somebody asks what time you ate breakfast this morning, you're probably going to get close, but you're not going to be exactly right. If somebody asks you what time you woke up, if you set your alarm for 6 a.m. every morning, well, you're probably going to get that right, But if somebody asks you what time this wreck occurred, then you're probably going to have issues with that, especially if you were injured, because you're not worried about what the clock says. You're worried about, why is my arm broken in half, or why is my neck on fire, or whatever's going on. Is the other person okay, or is my family okay that's in the car with me? So generally with time and distance questions, we think it's a good idea in most situations to overestimate if you have to answer the question, but just don't fall into the trap of getting boxed in.
Right, and it goes back to what we talked about earlier. You don't have to guess, right? If you can give a range, that's perfectly fine. And in fact, that's typically what I'll advise. Like, if you don't know, it's fine. You're not required to know exactly what time something happened, what the exact distance was, but it's certainly fine to give a range, right? It was between 7 and 7:30, or it was, between 3 and 5 car lengths in front of me, something in that nature, but you don't have to guess, right? So that's important. So I think lastly, kind of in the era that we're in right now, is that most depositions nowadays are being taken via Zoom or some, other video conferencing program. And it's important that anytime you're in a Zoom deposition, you treat it as if you were actually in the room with the people that are deposing you. Okay, I know that's really hard to do nowadays, especially with the, pajama bottoms and the business shirt on, but it's very important to treat it as if it's a real deposition, and also treat the deposition like it's going to be played in open court.
Yeah. And one other thing that just, I have to say this one because it gets under my skin so bad. If you're the injured party, if you're the plaintiff in most cases, if you're hurt, one of the central issues in your case is going to be your medical condition. And people get kind of uptight about, well, are they allowed to ask about my past medical history? Well, the simple answer is that they are allowed to try to find out, the other side, whether you've had this condition before in your life. So if you've got an injured neck, was your neck injury caused by the wreck, or was it something you were suffering with for 10 years consistently prior to the wreck, right? So lots of times you'll get a question, for example, if you do have a neck injury, the question may be, have you ever received treatment for neck pain before? If you're 50 years old, then chances are at some point in your life you've gone to the doctor and said that your neck hurts, or same thing if your back hurts. But it's not always necessarily the same injury that's causing the pain, right?
Or it's extremely minor.
Yeah, and you may not remember it. You may have zero recollection of going to the doctor 10 years before and saying that, you have the flu. Doctor says, where does it hurt? And you say, from my head to my neck, to my back, to my legs, to my toes, everything hurts. And the doctor dictates it into his or her notes. It goes into the medical record. Defense attorney gets his or her hands on that record and asks you, have you ever complained of neck pain before? And very innocently, you say, no, never. Well, that's not really true because you did, even though you don't remember it. So usually the best answer for those kinds of questions is, I don't recall that ever happening. Because if you really don't remember it, I don't recall is an honest and truthful answer, and it will keep you from getting boxed in the long run.
Right, and that's especially true, right, for typically the older clients who just might simply forget, right? Younger clients will know, right? If you're 20 years old, you've been an erected lump, you've been to the doctor in the past 10 years, showed with a back injury, but most of the time it's the older clients that just simply don't know or don't recall that one time when they were in their mid-20s and, were doing some yard work to tweak their back and happened to go to the doctor for that one visit, when in the grand scheme of things, it's not a big deal at all. But right, to Joel's point, you just never want to use an absolute to box yourself in the corner to say, oh, it never happened, never before in my life. So, yeah.
Yep.
Yeah.
All right. Well, that wraps it up for week 3 of our series of 52 weeks of personal injury. We hope that this video on how to give a deposition has been helpful to you. If it has, we appreciate you liking it, giving it a thumbs up, subscribing to our channel so you'll be aware when we come out with new videos. And if you have any comments or additional tips for other people, just insert it into the comment section below. And we'll see you next week for video number 4.